In this session, we will be exploring different strategies that work to ensure access to remedy. So as you know, Pillar 3 of the UN Guiding Principles outlines that states have a duty to ensure access to effective remedies and that businesses should also make available effective grievance mechanisms. Remedy is central to justice and accountability, but as we are all aware, it remains challenging to achieve. We have an amazing panel today who will share with us concrete examples and reflections on when and how to use different strategies to access remedies for business-related human rights violations. They will try to unpack what methods can help put pressure on businesses to ensure access to remedy and to change business practices. So I'm really looking forward to their insights on what has been used to strengthen agency and empowerment and to amplify accountability, especially for marginalized communities who often face exploitation and abuse, including of their human dignity and their environmental rights. At the heart of this discussion is the issue of power and rebalancing power. As we heard in the opening session this morning, how we can rebalance power in favor of those populations who often bear the brunt of the negative impact of business activities is something that we are trying to look at in this session, but also throughout the whole forum. So allow me to introduce our panelists. We have Mr. Oliver Holland, who is a partner at Lee Day, a UK-based law firm where he specializes in legal claims relating to environmental damage and human rights abuses involving multinational corporations. And then to my far right is Ms. Dr. Rana Sengupta, who is the managing trustee and CEO of Mine Labor Protection Campaign Trust, who works with stone quarry workers in Rajasthan, India to strengthen cooperative movement and collective action to protect human rights and the environment. To my left is Ms. Ghislaine Nadel, who is the Senior Sustainable Investing Specialist with Robeco's Sustainable Investing Center Ms. Ghislaine, Center of Expertise. Ghislaine drives the firm's engagement programs on human rights, biodiversity, and just transitions in Asia. And then last but not least is Professor Surya Deva, who is based with Macquarie Law School and is a director of the Center for Environmental Law at Macquarie University. Professor Deva is the UN Special Rapporteur on the Right to Development and has previously served as the member of the UN Working Group on Business and Human Rights. So let me turn first to you, Oliver. So you've worked on a number of cases related to environmental pollution as well as on labor and migrant rights. What are some examples of strategies that work to seek justice and reparations for communities and individuals that are negatively impacted by business operations? Can you tell us a little bit more about how we can use law and legal mechanisms, including strategic litigation, to support access to remedy? Over to you.
Thank you, and thanks for having me on the panel, and good afternoon, everyone. I thought I'd just start by just maybe giving a little bit more background about Lee Day, for those maybe who don't know who we are. We're a typical law firm in many ways. We're a law firm based in the UK. We've been around for 40 years or so, and we've successfully represented many thousands of individuals and communities from many jurisdictions around the world in private law claims in the English courts against many of the largest multinational companies. We use primarily tort law principles to establish liability against a company for harm that may have occurred from their operations, either directly or as a result of the operations of a subsidiary or in a company's supply chain. The common issues that these claims seek to address and to remedy primarily relate to environmental damage in the extractive sector, forced and child labor in supply chains, human rights abuses by corporations, and also sexual violence in the workplace. So litigation in itself is, of course, a potential access to remedy. But when many people think of litigation, they often think of the eventual sort of end goal of a liability trial and a finding for one party or the other. However, it's important to stress that it's very rare that a legal case, goes to a full liability trial, and almost all cases end up settling along the way. So with litigation, access to remedy is often created by the fact of the litigation commencing in itself rather than the end point. In a complex legal case, it would normally take somewhere between 3 and 5 years to conclude if you went to trial, but during that period there are multiple pressure points along the way that may lead to access to remedy. And just to take sort of 3 examples of that pressure that litigation creates. First, it's the litigation in of itself, so commencing it, starting with, in English law, you have to start with engaging with the defendant before you issue proceedings. And that gives an opportunity for negotiations to take place and to prevent from litigation actually ever occurring and for remedy to be given to the claimants. The second point is just on media. Our cases often receive a lot of attention in the media, and often the media feel that they can report more widely on legal cases because they're protected more than, against things like slap suits, because they're protected by the fact that there's a legal case going on. And that obviously highlights the issues that are in hand and creates that kind of additional pressure, particularly when you're talking about corporations that have a consumer-facing element to them. And just the third point, the risk of losing at trial is often a deterrent from going to trial, and often a point where we end up settling cases. Defendants often don't like to take the risk of going to trial. Just to give one example, we represented a community in the Niger Delta, a community of about 16,000 fisher folk and subsistence farmers, where Shell had polluted their waterways and their farmland, totally eradicating the place, taking away all of their ability to be able to sustain themselves, destroying their creeks. In that case, at the beginning of the case, prior to our involvement, Shell offered the community of 16,000 people £4,000 and 100 bags of rice in compensation when they had removed their ability to live forever. We took the case on 3 years later, and 6 months before trial, because Shell did not want the risk of going to trial and losing in that way. We ended up getting them £55 million, and also the remediation and cleanup of the waterways. And for those that don't know the Niger Delta, it's a very polluted place with lots of oil spills, but there's never really been any effective cleanup conducted there or remediation conducted there. And this was the first time that a multinational company in the Niger Delta had committed to a proper international standard cleanup and remediation. So that's an example of the ability to be able to use litigation in that way and create the pressure on the defendants. And just on settlement, settlement presents an opportunity to go beyond providing just compensation, which ultimately is what the courts can award. We, in recent years, have been focusing on restorative justice measures, trying to be creative with the settlement processes that we're going through. And it's something that corporations and companies they are sympathetic to. And we've had some very creative settlements recently where many restorative justice measures that you couldn't get through the courts have been used. Finally, it's important to note that there are also many indirect impacts of litigation that maybe are not always obvious. Obviously, through raising awareness of the issue at hand, it may mean that the litigation continues and is fought, but it also results in the company potentially looking at, for example, their supply chain and looking at what the issues are and trying to address them, even if they continue to fight the case in court, they may improve the way that they operate anyway, and it also has a deterrent effect. So often you see in some examples we've seen where the industry that's being litigated about, but is not part of the litigation itself, will end up changing their ways and improving conditions for workers, etc. So there's this sort of indirect effect of litigation that's really important as well. So in summary, under the umbrella of sort of the pressure of litigation, there are many routes through which access to remedy can be achieved.
Thanks, Oliver, and thanks for highlighting that it's not just the end result of the litigation, but that it can be a strategy itself or a way through which to put pressure at different points along the way. Maybe just as a quick follow-up question, you gave the example of working in the Niger Delta, but also how do you engage across different jurisdictions, because you're working with different multinational companies and actors. How have you navigated that, and how do you ensure access to legal remedy across these different jurisdictions?
Yeah, that's an important point. I mean, the first point, I suppose, is obviously we don't get many Niger Delta fishermen walking through our door in London asking to be represented. We are totally reliant on CSOs, human rights defenders who are aware of our work and come to us and support us hugely, and without them we wouldn't be able to operate at all, really. They raise these issues for us, they bring them to our attention, and that happens in multiple jurisdictions around the world. We have many cases across the African continent, across South America and Asia, but all of these cases are brought in the English courts, so they have to have a link to the UK in some way, whether that's through a UK company's supply chain or through a parent company relationship. But to sort of address your question more directly, there are many challenges, jurisdictional challenges, and obviously it creates more opportunity for defendants to delay proceedings procedurally, and so that can result in many sort of procedural battles along the way. For example, a recent example, we're representing a group of migrant workers from Nepal and Bangladesh against Dyson in relation to forced labour in their supply chain in Malaysia. And in that case, we commenced proceedings in the UK, but the defendant challenged the jurisdiction of the UK, arguing that the case should be heard in Malaysia and not in the UK. That case is now going to the Court of Appeal later this year, but it just illustrates the kind of delays and jurisdictional issues we have. And we also have, the other issue is having to deal with and learn about different cultural norms and things like that, which again is where sort of CSOs come in and support us in that way. And then sort of finally, there are obviously many cases around the world where we can't represent people because there's no UK link. But there we try to provide support to local lawyers. We've brought cases, for example, in the South African courts, working with local lawyers in that way as well.
Thanks, Oliver. I'm going to turn now to Dr. Sengupta. You've been working on labor rights, particularly with stone quarry workers in India. So stone mining has significant environmental impact along with human costs. Can you tell us a little bit more about your experience and how you were able to put pressure to bring about change in business practices? Did you seek remedy through judicial bodies, non-judicial mechanisms, independent institutions? Can you tell us a little bit more about the case and sort of the avenues that and the strategies that you adopted?
Thank you. Rajasthan is one of the states in India which is the highest producer of minerals, and there are approximately 33,000 mines and quarry licenses. Most of them are of natural stones, what we call dimensional stones also. 33,000 mines employing approximately 3 million workers. So a study was done some 15 years back which revealed that among the women workers, 48% of the women workers are widows of mine workers. When we investigated, we found that it was because of silicosis, a disease which is not curable. And after investigating into it, we also did a report which is known as Budpura Ground Zero in 2005. Budpura Ground Zero revealed the story of the supply chain of natural stones from Rajasthan to the rest of the countries and also domestically. After the report, there were companies who were trying to become responsible. They tried a lot of initiatives also, but most of them were actually irresponsible. They gave a blind eye because they were referring to the laws which were prevailing in India, They said that if the Indian laws are not able to safeguard the workers' interest, what can they do? So 2009, there was a complaint registered with the Human Rights Commission, the National Human Rights Commission on silicosis cases. And due to the investigation of, or the intervention of the Human Rights Commission, the state were compelled to pay monetary relief to the workers. During the first case, there were around 21 widows and 48 who were alive. So government gave 300,000 rupees as monetary relief. But then the cases started coming up because there were thousands of such cases which are not reported because the doctors never knew that it is a notifiable disease and needs to be notified to the regulatory authority. So because of non-compliance, these thousands of people were actually, they were in the villages, they knew that they were suffering from TB and they died. But it was actually silicosis, which was on record but not revealed. It took almost 5 years to make the government understand that it is not just an ex gratia, it is the failure of the compliance mechanism. And in 2013 onwards, the government took a proactive step and then declared silicosis as a state epidemic. That was the first intervention that the state did, and it was really appreciable, so that they could bring the focus on for disease which could be prevented, and there is no cure. 2019, not very far, government of Rajasthan became the first state to set up a pneumocnosis board, which detects diseases like silicosis and pneumocnosis. From 2019 till date, there are 100,000 people who have been diagnosed, out of which 40,000 people have been confirmed suffering from silicosis. So it's approximately 40%. And the money that the government has paid off is 520 crores, which is approximately 6.2 million as ex gratia, and continues to pay as pension. And these people, when they will die, eventually the government's financial burden would be 800 crores. That is 9.5 million. So why is government paying and the industry is not paying? So we need to understand the setup in which these licenses and leases are given. And they are also the backbone of the economy. So definitely the government would be earning much more than what it is paying. But what about human rights? So what we analyzed from that situation was, government is bothered about its revenue. And once it takes its revenue, it is not bothered about the supply chain. And that was the supply chain or the value chain which needed to be investigated. So 2023, we did another report of Bhutpura Ground Zero. We are putting it up on air today for you all to see what happened. Now the change which is coming up, the government still continues to pay off. But now there's a new law which has come up, which is the corporate due diligence directives, which has brought the buyers or the companies now to talk about what can be done. So there is no mechanism because the trade unions were not encouraged, the laborers were suppressed, there were no investigation or nothing which could be done because the labor department is different from the mining department. The labor department doesn't earn for the state. So they are not asked or not heard. Now with the new law, now the companies are coming up what can be done because they can't change the business. What happened in 2023 was people have died in Bhutpura. It is known as the village of widows because they're all widows. The stones have moved out from the stocks and have been dumped in front of the houses so that the stocks is free from child labor and women. So all houses are now breaking stones. The tragedy is what they are being paid for one kobal is 1 rupee 50 paisa. I don't know how much it would be in dollars, but 1 rupee is the minimum currency in our country. So 1 rupee 50 paisa is 1 kobal. What they can break is 100 kobals a day to the max. So once the bread earner dies, the entire family is breaking stones. And these kobals are 100% export oriented. So to track the value chain and to make the business responsible, there is a question: who will do it? because we don't see any setup where the workers have been organized, because they can't organize. They are already indebted. For every small money which they require, they have to take it from the contractors or the middlemen. So any form of a mechanism to ripple this particular issue, or means like to respond to this, is a big question. And we feel that now it is the companies who didn't bother to 2005 have to come up for 2024 report. Thank you.
Thanks for sharing that experience with us, and also discussing how you approached the National Human Rights Commission, and it was able to get compensation, but the challenge still exists in terms of accountability of businesses. In terms of your engagement there, do you see any role that civil society plays in terms of pushing for accountability? What more can be done in terms of broader engagement and mobilization to strengthen accountability of businesses themselves?
The businesses have to talk with the government and share their challenges. And also, the government have to extend some support, some kind of a mechanism where at least the workers can be brought into one place, like a cooperative model. That is something which is viable in the present context, where the widows can come in, they get the right prices from the cooperative, and they don't depend upon the brokers. And this receipts of movement of the traceability or the transit of the mineral can assure the buyers that they have set up such mechanisms which can uphold or resolve the problem of the women workers. Because the women workers don't have any alternate livelihood now.
Thank you very much. I'm going to turn now to my left, and we're going to talk about another strategy and approach. So, Ghislaine, being an investor, you also have different strategies to put pressure and create incentives for businesses and changing business practices, right? So one way is through shareholder activism to guide business activities. How do you see the role of shareholder activism or responsible investment practices in addressing human rights violations? Can you share any examples of when that has been successful?
Thank you, Aparna, and thank you for having me here and to share the investor perspective. Maybe briefly an introduction as well on Robeco, because I think not everyone knows Robeco. We are a global asset manager based and headquartered in the Netherlands with around $180 billion assets under management. Our clients are institutional clients, pension funds, insurance companies, and wholesale clients, meaning banks and family offices. We invest only in listed companies, and Robeco has been a pioneer in sustainable investing, which means that we integrate environmental, social, and governance factors in our investment processes and decisions. And we truly believe that companies that are better performing on sustainability, respecting human rights, are better performing companies financially as well and have a competitive advantage. And in addition, it's of course also about reducing the risks across our portfolios. Robeco has endorsed the UN Guiding Principles and other human rights related standards, and human rights is one of the 4 key areas in our sustainable investing strategy, next to climate, biodiversity, and sustainable development goals. Shareholder activism and responsible investments are indeed important pressure points. So one example of how investors can use their influence is via voting and engagement. So within Robeco we have a human rights voting policy, which means that for companies that are not taking adequate steps to mitigate their human rights impacts and are linked to social controversies, we will vote against management at the annual general meetings. How do we identify these companies? Well, we use the corporate human rights benchmark, and we identify companies that are scoring below average on the human rights due diligence metrics. And we also use Sustainalytics, a research provider, to identify controversies, so companies that are non-compliant or on the watch list of the global standard screening list. Those are the companies that we have in scope. So, for example, last year we voted against 15 companies. On top of that, we can also file shareholder proposals. So one example is that we're engaging with a tech company, but it was very difficult to get access to the company, and as a result also to get information. So with other investors, we filed a shareholder proposal asking for an independent human rights impact assessment report to assess the company's approach to misinformation and disinformation. And the proposal got a lot of support, and as a result, we got in touch with the company. It was discussed on the board level, and the company came with a human rights impact assessment, an independent human rights impact assessment. So these are a couple of examples of, and then of course that's the first step, because the engagement continues. And that links then as well to our engagement role as an engager, so speaking with companies on bilateral basis or collaborative basis. Collaborative is of course more influential because you increase your leverage. But if we talk about human rights violations, in those cases where we screen, we use, if we identify a breach of the UN Global Compact principles related to human rights, we will start an enhanced engagement, which means that we will engage with the company to lift those breaches. And if the engagement is not successful, we will divest. Normal period of time that we will use is 3 years, but we can divest sooner if the engagement or the progress is not successful, or if we are not successful in speaking of getting access to the company. Of course, we will try in the meantime all kind of ways to get access to the company or to increase our influence. So other investors, but also other financial institutions, consultation of experts, human rights experts, like UNGP team, for example, as well. Other representatives from civil society. So I think we are always looking for new ways to increase our leverage, because divestment is really the last solution. And if we divest, it means that it has not been successful.
Thanks very much. I think you gave a range of different examples. Also, even the threat of divestment, you're saying, can also spur change, right? Are there particular initiatives to ensure due diligence standards are not just met, but enforced? Can you share some examples of that?
Had the engagement that I was just referring to had the outcome if it's not successful is divestment. But we also have other engagement programs where we proactively engage with companies on specific human rights themes that we identified. So a few years ago we identified the issue of companies active in conflict-affected areas. And the engagement objectives in these in this engagement was policy commitments, enhanced due diligence, specifically for conflict-affected areas, remediation, reporting, and performance management. So human rights due diligence and enhanced human rights due diligence is a specific engagement objective. We also have modern slavery in supply chain engagement, where we engage with 10 companies from 5 different sectors, on engagement objectives such as governance, policy commitment, quality of human rights due diligence, remediation, prevention, and corrective action. And last but not least, because this morning I was also attending the session on just transition. We have a specific program where we engage with companies from energy and mining companies that are active in emerging markets on the just transition. And also there, an important engagement objective is just transition risk management, where we refer to human rights due diligence. And engage with the companies on the quality of human rights due diligence. So these are engagement programs where the outcome is taken into account in the investment decisions. Maybe important to mention is the engagement is collaboration internally of our SI research team, but also our investment teams. And that is, I think that is more powerful towards the companies that you engage with if the investment teams are present there as well, because it can influence the investment decisions, as I just mentioned. On the just transition engagement, so far we engage with companies active in Indonesia, Malaysia, India, China, and we have seen that we started the engagement about 1 year ago, that it starts with building up the relationship, but also to introduce the topic of just transition and that it is relevant for investors. So it was also, a lot of companies were surprised actually because they expect our interest is in just the transition, the climate story, but here we underline the importance of human rights and that the companies should integrate just transition considerations in their human rights due diligence, in their energy transition plans, for example, and also in their reporting frameworks. So that's corporate engagement, but what we have seen as well is that certain companies, if the government is not really pushing them, it is important to do public policy engagement and sovereign engagement. So together with other investors, we do that as well. That means as well, for example, providing input to consultations, to taxonomies, to, for example, in Singapore, we have the MAS transition guidelines. So we provide feedback and we underline that the transition should be credible, financial viable, but also social inclusive. So we really push that also within the industry, in the financial industry, that guidelines on transition, on energy transition should also include guidelines related to social inclusivity. So that means having environmental and social impact assessments in place during the human rights due diligence, the stakeholder engagement, not only workers, but also the communities and the business value chains that are impacted and consumers by the transition.
Thank you very much, Ghislaine. So I'm going to turn now to Professor Deva. So Professor Deva, I mean, we're coming to you last but not least, but really, I think we've heard from the rest of the panel, a range of different perspectives, the different types of mechanisms and strategies that can be used, litigation, collective action, working with oversight bodies, but also shareholder activism. Can you, from where you're sitting, talk about what the key pressure points that can be used to change the power balance, right, that we referred to in the beginning, and influence corporate decisions? How can we strategically leverage different pressure points to ensure that companies and investors take accountability seriously? So over to you.
Thank you, Aparna. And from the three presentations by Oliver, Rana, and Ghislaine, I will start with two common threads. There are many threads we can make, but one is that the barriers to access to remedy remain, and we can also notice significant power imbalances. So whether we're talking about these workers in Rajasthan, or we're talking about the people living in Niger Delta, or the other cases that Ghislaine mentioned, it is almost impossible for them on their own to hold these multinationals accountable. The second thread that I would like to mention is that it seems that the people are using beyond Pillar 3 mechanism already. Like Pillar 3 of the UN Guiding Principles is talking about three kinds of broad access to remedy mechanism. And these are all useful. And the National Human Rights Commission that Rana mentioned is going to fit into that. The courts that Oliver mentioned in terms of litigation will fit into it. But then we also see the dynamic role that investors can play and shareholders can play, and they are not really fitting into the three mechanisms mentioned in Pillar 3. And I think that is where the idea of pressure points come into picture. So as people in this room will realize, Professor John Ruggie started to shift the narrative from naming and shaming to knowing and showing. But I believe personally, and I think that is where the pressure points come to picture, that naming and shaming has a role to play. Because sometimes, if the companies are not knowing and showing, naming and shaming may trigger them to know and show. And I think that is where the pressure points come into picture. So companies are, of course, powerful institutions, but they also have weaknesses. And in the policy briefs that we are developing, I will mention 4 of those weaknesses, even of big multinationals: financial, reputational, operational, and regulatory. And I think in these presentations, some of these are already highlighted. Like when Rana was talking about the impact of CSDDD, that is a regulatory weakness that we are exposing. When we're talking about financial, that is where investors and shareholders come into picture, right? And of course, Oliver mentioned about the media, right? So it is very interesting that the lawyers litigating inside the court are paying attention to what is happening outside the court. Not just an accident, but as a tactic, right? And I think that is where the reputational dimension that companies are not willing to take the risk of going to the trial becomes relevant. That is a reputational weakness that we are trying to exploit. So basically what I'm trying to highlight here is that we have to look at the wider ecosystem in which we are exploiting the formal mechanism which are there as part of Pillar 3. But I think we also need to leverage something which is not counted as a remedial mechanism, like investors' resolutions, shareholder resolutions, the civil society mechanism. I also say social media campaign. There have been hashtag campaigns against multinationals, and that hashtag campaign in itself has forced the company to come to the discussion table and try to address those concerns of the communities. And I think those are the pressure points we're talking about here. And we will talk about later in another session the special procedures, for instance. Now, technically speaking, a complaint to special procedures of the United Nations is not an access to remedy mechanism, but it can be a pressure point. Civil society advocacy, shareholder activism that is already mentioned, consumer boycotts. So these are a variety of what I will call pressure points that can be leveraged either in isolation or in combination with the formal mechanism that has been mentioned. For instance, sometimes you file a complaint before the national contact point under the OECD guideline, and at the same time, you start doing a social media campaign to expose the company. Because what happens is that once you make a complaint, the NCP is going to ask the company, oh, do you want us to mediate? And the company may say no. But if there is a social media campaign which is complementing the complaint, then the company may be forced to react to that request and may be more willing perhaps to mediate with the victims, right? So I think that is the dynamic relationship we're talking about here between the formal mechanism as well as the non-formal mechanism which may be regarded as pressure points. And as Oliver rightly highlighted, sometimes you litigate not to win the case in the court. You know that you may not win. I mean, of course, some of the cases are very strong, so you may win that at trial. But sometimes you are litigating being fully aware that you don't have a strong case. And that is the strategy you consciously use, and then you are trying to leverage it by social media, by making a complaint to you in special procedures, and so on and so forth, so that you get the end outcome. The end outcome is to seek remediation, to hold the companies accountable. And I think sometimes those creative methods of pressure points are bringing those outcomes which are not formally contemplated by the UN guiding principles.
No, thank you. Thank you for that. And I think you summarized that quite well. And I think encouraging us to think beyond Pillar 3, right? And I think it would be, if you can talk a little bit more also about whether timing and sequencing matters. You certainly highlighted, that it's not that you use one strategy in isolation, that you actually need you can take a number of different strategies and have them complement each other. But also if you have any views on particular sequencing or coordination that needs to, that would be useful to take this forward, would be really.
Thank you. That is an excellent question. It's an excellent question because there is no one-size-fits-all solution. So it is not possible for affected communities and rights holders to go to a shopping mall and say, oh, I'm going to use the strategy A and B, pressure points. Every case is unique and every pressure point has a limitation. Let us say if you are dealing with a public-facing company, social media campaign will work very effectively. But if the company is unknown, no one knows it in the market, then the social media campaign will not bring that result. If the company is a state-owned enterprise and the government is supportive of that company, then that company may not really be bullied, let us say, by the shareholders and divestment threats because they don't care, because the government is supportive of that particular project. So I think we need to be aware of those factors. And I think that is what, Aparna, we are trying to develop as part of these policy briefs, that we are going to unpack those variables for each of the pressure points. So it starts with what I called mapping is the first stage. You identify what are the options, how many victims are there, what are they looking for in terms of remediation. Then you kind of identify what are the options, and then you make an assessment based on those variables that which pressure points may be more effective on the facts of this particular case. And then most crucially, how do you utilize the engagement windows? Let us say there is a litigation, or there is a complaint to NCP, or there is an investor resolution. Now company may be willing to negotiate. So then the question is whether the people on the ground who are impacted, are they ready to grab that opportunity? So that engagement window that is created by the pressure points, you need to be in a position to exploit that engagement opportunity. So sometimes these pressure points can be used in a sequence. So you escalate slowly. Let us say you can start with social media campaign. If it doesn't work, then you go to shareholder and then litigation or NCP complaint. So that is, let us say, a sequencing approach. So you identify 3 pressure points and you start with one. If it doesn't work, you go to the second one and so on and so forth. But the second strategy could be not sequencing, but you could simultaneously try 2 or 3 together. And then you're trying to manage the limitations of each and every pressure point. So I think we need to look at those specific variables to develop, let us say, a strategy for each case, that how to go about it. Thank you.
No, please, go ahead.
Yeah, I just wanted to quickly respond to what you mentioned on timing, and if I link it back to voting and filing shareholder proposals. We share our voting approach before we vote, of course, with the companies, and also shareholder proposals, and I think especially in shareholder proposals, there's quite a high percentage, because then the company is responsive, then you start engaging with the company before you file the proposal, and sometimes that is successful. Yeah.
That is my precisely point, right? So instead of going all out against a company, this engagement strategy that you put the company on notice, and that is also Oliver highlighted in terms of litigation, right? So before you're actually filing a case, putting the company on notice that we are going to sue you or we are going to bring this resolution, that may trigger some companies to start engaging with you and provide remediation. But many will not. And I think then you need to adapt and trigger in other pressure points or other remedial mechanisms. Thank you.
Thank you. And I think, as you mentioned, we're putting together these policy briefs that will be looking at what are these different tactics that can be used either independently or in combination, and how they can actually push companies, right, be this pressure to change their behavior or to even bring them to the negotiating table in the first place. So I'm now going to open the floor for any questions. Please raise your hands, and I'll take a few questions and come back to the panel. So maybe we start here, then there, and then in the back.
Thank you, Chair. My name is Ajay. I'm representing Lions of Climate Frontline Community. And I have this, burden of bringing this, unfair things on the table. I would like to ask a question to Mr. Rane. The fact is the most, almost all, or if not, the most of the workers, that 3 million workers in 30,000 mines in Rajasthan you're talking about, either belong to Dalit or Adivasis, which gives us an understanding of a casteist or racial undertone of the entire scenario, which is the reason why the government and companies go the lethargic kind of approach, declaring some, peanuts for pensions and for, they are quite sure that these people are going to die. Okay, you will be provided when you die some X money. And and now my question to both Dr. Suryadev and the gentleman sitting next to you, what are the pressure points we can use to bring this issue? The Dalits and Adivasis themselves not able to do that. because most often these companies actually rob their land, taken over their land without any compensation. They become the laborers in the company who took their land and they die there. So we can't, even think of the community come up their own for any solutions or anything. But is there any ways and means we can engage? Thank you.
Thank you. I think there was a question on the right here.
Ben Harden from Earthrights International. So Earthrights engaged with various investors following the Myanmar military coup, particularly investors in the gas sector. And one of those investors in that gas sector was Robeco. So I'd like to share kind of a slightly different perspective on the challenges of engaging with investors. I think as a starting point, we're talking about sustainable investment here. Well, Robeco does unfortunately invest in fossil fuels. And so I think as a starting point, in the last session there was a gentleman from Kiribati. I think he would say that responsible investment shouldn't include fossil fuels. But I think eventually Robeco did divest from PTTEP, a Thai company that's one of the largest sources of funding for the Myanmar military. And it's one of the few investors to do that, and I think that is definitely a very positive step. But I think it should have happened a lot faster. This is the largest source of funding for the Myanmar military. The coup was in February 2021. In December 2021, other investors were calling on Total Energies to divest, stating it was funding atrocity crimes. I first engaged with a group of investors, including Robeco, in 2022. Myanmar activists wrote to them in 2023. They still had not managed to divest. They finally did so in 2024, which was, as I say, a very positive step, but far too late. And so the UNGPs do obviously apply to investors. They should be using their leverage to ensure that companies are responsible. But you mentioned a couple of things. One was that you spoke with Sustainalytics. Sustainalytics continued to list PTTEP as a responsible company, stating that it was safe to invest in, despite it being a large source of revenue for the Myanmar military. And so what I would ask is, how do you think you could improve your human rights due diligence to ensure that you are not investing in a company contributing to human rights abuses in Myanmar 3 years after the coup? And to give an example, when you did divest, which was, like I say, a positive step, it would have been good to see a public statement saying you were divesting because PTTEP is linked to the Myanmar military. And using that leverage very publicly would have been a positive thing. So I was wondering why that didn't happen.
Thank you. There's one more question in the back there, and we'll go back to the panel, and we'll see if there's time for another round.
Okay, thanks, Aparna. Good afternoon, everyone. My name is Sofyan from Indonesia. I'm working for the Seafarer and Fishermen Union in Jakarta. Last 3 years, I got a complaint from the Indonesian fisher who work in the Chinese fishing boat or operate in the Pacific Ocean. That fishing boat using the flag of compliance now to flag. After 1 year's work, the owner did not pay their salary. And then they're back home to Indonesia and then report to my union. And then we do the litigation process and then go to the Indonesian, how to call that one, in the court. And then court said the manning agency have to pay 500,000 US dollar. But unfortunately, the manning agency, they cut by police to another similar case with the government agency. And then, until now, we did not get the payment from the owner. So, can you tell the panelists any mechanism or have to follow so that I can get the remedy from the ship owner in China? Because this unlogical I fight with the mining agency in Jakarta, but the ship owner can sleep well and eat well in China. They get collect all money from the fishermen. And thank you.
Thank you very much. Maybe I turn back to the panel now in case they want to respond to any of the questions. Maybe we can start here.
Yeah. See, 95% of the workforce are Dalits and Adivasis in Rajasthan. And the government, while they were trying to give leases or licenses, they gave preferential rights to these communities, 10% for scheduled caste, 10% for scheduled tribe, and 10% from other backward communities. And that was through lotteries. So just imagine when you have to pay a very small amount to take a lease, but then you don't have money to invest on that lease or a license. Then there is a proxy mining that takes place. So most of these workers, not most of them, but many of them, are trapped into their own mine. They gave away the mine to somebody else. This was on proxy. And they were working into those mines exposed to silica dust. And they got silicosis. So the remedy which we are also looking for is, we know that it is a notified disease, fine, before 2010, before the NHRC came into the picture. The doctor didn't know that it is a notified disease, it's a human error. But what after 2019? Now there is a silicosis portal of the government of Rajasthan. You apply for a screening, within 15 minutes you'll get a designated hospital nearest to your point from where you're applying. Within a day you will get a diagnosis done. And within few hours you'll get the report also. It'll take some time to get the money because it gets into some financial departments. But that portal doesn't even notify. And there is a penal provision for not notifying it. It is 10,000 rupees. But 40,000 cases screened by the state of Rajasthan and not notified to the regulatory authority is an offense. So what we have recommended is that all the cases which are being diagnosed should be notified and also immediately referred to the District Legal Service Authority, which is meant to provide free legal assistance to the poor people. But our concern is also on the prevention part. If it is a preventable disease, what is happening to the prevention part of it? Why is the state not taking any proactive step to prevent this from happening and save the lives of the people? So ultimately, if we see or analyze it, it is the state which is the principal employer. It has given the leases or licenses on royalty. So we are drafting some mechanisms to reach out to a legal course where the state can take some steps to save the lives of the people. Thank you.
Yeah, I could probably address maybe just both of the first and last gentleman's questions briefly. As a lawyer, I naturally just think about litigation. I find it hard not to. But I think the main thing is, without commenting on the specifics of either of those cases, the main thing is both cases concern supply chains and where do these products end up. Obviously, we're talking about the stone and where that ends up, and you're talking about fish and where does the fish end up. So I think the really important thing here is transparency in supply chain, so we can see where things are ending up, and then looking at the responsibility up that value chain to the end user, to the consumers, to the companies that are selling them to consumers in Europe or in the UK. I think that's something that's really important, greater transparency in supply chain so that we can trace these sort of things.
Can I turn over to you, Elaine?
Yeah, thank you. And thank you, Ben, for sharing the example or the issue with PTTEP and the terrible situation in Myanmar. We indeed have, as I mentioned, we had a specific engagement program on companies operating in conflict-affected areas, amongst others, indeed Myanmar and PTTEP. And I think this is a very good example of pressure points and looking for pressure points, because we did not only engage with the company. Once we approached the company, and that was soon after we launched that engagement program, the company has been very responsive to us. We had regular engagement, but we also engaged with human rights experts, with Myanmar Center for Responsible Business, with academia, with other banks, with other financial institutions to see are there ways how we can increase our leverage and to impact PTTEP's activities in Myanmar and the joint venture with MOGE, the government-related entity. That has not been successful, and indeed we did not straight away divest, but we really wanted to use and seek pressure points to have a positive impact. So we divested indeed, and we published this in our sustainability report, in our active ownership report, so it's public available information. We use indeed Sustainalytics as a research provider. Sustainalytics does not list PTTEP on its watch list or non-compliance list, but we do additional analysis. Our own research team, we also use other sources as well, other research providers, so it's really a mix, because we see indeed that the controversy score that these type of research providers use are not always reflecting the issues as we see them. Also a point is we continuously work to improve our human rights due diligence and our own approach, and that's also why this week for me is very valuable to hear the voices on the ground. For example, now this forum is on remedy, access to remedy, and I'm learning a lot on what are the challenges and what are the solutions. So we are continuously working on improving our own activities on human rights.
Thank you. I think we're running out of time, but I think I'll give the last word to Professor Deva, and then we can conclude the panel. Thank you.
Thank you. I will just quickly combine the first and the last question in terms of what pressure points to use in the case of Indonesia or the Rajasthan Dalit case that you have been talking about. So I will say it will require the pathological or forensic examination of who the defendant is. So who are the consumers, who are the investors, who are the shareholders, what are the legal and policy frameworks, and then one can identify the most suitable option in terms of that. I give a concrete example to explain how it works in practice. So there was, as you know, Kenya supplies a lot of flowers to all over the world, but to the UK supermarkets as well. So there were a lot of cases of sexual harassment of women working in the flower industry in Kenya. And the local company and others, they were just completely ignoring that issue. Then they collaborated with an NGO based in England. And what this NGO in England did, they merely stood outside the supermarket selling flowers with the placards, the sexual harassment linked to these flowers. And that triggered the pressure on the company back in Kenya. So the communities in Kenya don't need to travel. So the power is the collaboration, power is the creativity, finding out those weaknesses of each company and pressure points, and then putting pressure where it matters. And then hopefully companies will react and address those grievances. Thank you very much.
Thank you very much. Let's give a round of applause to the panel. Thank you for your questions, and thank you very much for staying engaged.